The U.S. Supreme Court delivered a major decision today, one that will limit federal judges' power to block the president's agenda nationwide.
Following a Supreme Court ruling that limits the power of federal judges now to issue a nationwide injunction.
The Supreme Court was taking up this central question about whether a lower court judge has the ability to block the policy and his agenda.
Justices have just ruled on whether a single federal judge has the authority to issue what are known as nationwide injunctions.
The Supreme Court usually releases its most anticipated rulings over several weeks or days. Not this year.
All right, stop everything you're doing right now, because what I'm about to walk you through is genuinely one of the most significant Second Amendment developments in modern American history. A federal appeals court just dropped an 87-page ruling that doesn't just poke holes in carry bans, it detonates the entire legal foundation that anti-gun states have relied on for decades. And the most explosive part of this decision, the piece that has gun control organizations scrambling behind closed doors in full-blown crisis mode, is buried deep in the historical analysis where these judges traced firearms rights all the way back to 1328. Yeah, medieval England. What they found there creates a chain of legal precedent so unbreakable that restrictive states are essentially out of options. But before we get to that, there's something even more devastating hidden in this ruling that almost nobody is talking about yet, and it has the potential to invalidate thousands of gun-free zone laws across the entire country in one sweep. So let's break this whole thing down piece by piece, because every gun owner in America needs to understand what just happened. Let me set the stage for why this particular ruling is different from every other court victory we've celebrated over the past few years. This isn't some narrow technical win on a procedural issue. This isn't a judge saying one specific provision of one specific law goes slightly too far. What happened here is that a 3-judge federal panel took an entire state's residency-based carry permit system and declared the whole thing unconstitutional, the entire framework gone. And they didn't do it with some creative legal theory that could be easily overturned. They did it by building the most comprehensive historical case for the right to carry arms in public that any federal court has ever assembled. We're talking about a decision that traces an unbroken line of legal protection for armed self-defense across nearly 7 centuries of Anglo-American law. From the Statute of Northampton in 1328 through colonial charters and founding-era debates through Reconstruction and right up to the present day, Judge Catherine Polk Fail authored this opinion, and what she produced isn't just a court ruling, it's essentially a masterclass in constitutional history that leaves anti-gun legal scholars with nowhere to hide. Now here's where things start getting really interesting, and this is the part that gun control advocates were praying no court would ever discover. The judge didn't just look at what historical governments did when it came to regulating firearms. She looked at what they deliberately chose not to do. This is a legal technique called negative historical evidence, and it completely flips the script on how Second Amendment cases have been argued. See, ever since the Supreme Court's Bruen decision, the government has been required to show that any modern gun restriction is consistent with America's historical tradition of firearms regulation. So what anti-gun states typically do is dig up some obscure 200-year-old statute and wave it around as proof that the founders were totally fine with gun control. But Judge Fail turned that entire strategy on its head. She went through periods of colonial wars, frontier expansion, civil unrest, and documented public safety emergencies, and she found something remarkable. Even during the most dangerous and chaotic periods in American history, governments specifically and deliberately rejected proposals to restrict the carry rights of travelers and non-residents. They had the opportunity, they had the justification, and they still said no. That creates a historical record that is absolutely lethal to the government's position, because if the founders wouldn't restrict carry rights even during wartime, how can modern politicians justify doing it during peacetime? But it gets even more devastating than that. The court documented 23 separate historical examples spanning from 1690 through 1868, where governments were presented with opportunities to ban public carry and explicitly chose not to, 23 times. And in every single instance where historical governments did impose some form of regulation on carrying arms in public, they did it through objective, shall-issue type systems. Never once through the kind of discretionary may-issue schemes where some bureaucrat gets to decide based on their personal feelings whether you deserve to exercise a constitutional right. This finding alone obliterates the legal strategy that states like New York, California, New Jersey, and others have been running for generations. Their entire approach has been built on the assumption that discretionary permitting has deep historical roots. This court just proved it doesn't. It never did. The whole thing was a legal fiction. And speaking of legal fictions, let me tell you what the court said about so-called sensitive places, because this is the section that's going to send shockwaves through every state legislature that's tried to ban guns from public spaces. After the Bruen decision came down, anti-gun states thought they'd found the ultimate loophole. If they couldn't ban carry outright, they'd just declare every square inch of public space a sensitive place where guns are prohibited. Airports, public transit, parks, restaurants, theaters, hospitals, sidewalks near schools, sidewalks near government buildings, basically anywhere a human being might actually exist. Some jurisdictions were literally trying to designate 95% of their public territory as off-limits to lawful carry, which effectively recreated the carry ban they'd just been told was unconstitutional. The court saw right through this and demolished it with one devastating piece of historical analysis. The judges found that in the founding era and throughout the 19th century, there were exactly 4 categories of locations where carry could be historically restricted: legislative assemblies while they were in session, courthouses during active proceedings, polling places on election day, and schools. That's the complete list. 4 categories. Everything else, including churches, markets, public gatherings, government buildings, and even powder magazines, was fair game for lawful carry. So when modern states try to declare shopping malls and public parks as sensitive places, they're not following historical tradition. They're inventing restrictions that have zero basis in the constitutional record. But here's the legal grenade buried in this section that most people are completely missing. The court ruled that even in those 4 legitimately sensitive categories, the government cannot impose blanket bans on firearms. Instead, they're required to use what's called the least restrictive means possible. That means things like secure storage options at the entrance, temporary surrender procedures, or specific exemptions for trained permit holders. This single requirement is going to invalidate thousands of gun-free zone laws across the country because virtually none of them use the least restrictive means. They all just slap up a sign that says no guns and call it constitutional. Under this ruling's framework, that approach is legally dead. Now let's talk about the constitutional architecture of this ruling, because this is where the legal genius really shines, and it's the part that makes this decision nearly impossible for anti-gun courts to work around. Judge Fail didn't just rely on one constitutional provision. She wove together 3 separate doctrines into a unified legal test that gun restrictions must pass, and it's a test that virtually no carry ban can survive. First, there's the text, history, and tradition test from Bruen, requiring the government to prove any restriction matches America's historical firearms tradition. Second, the court applied strict scrutiny under the Equal Protection Clause because residency-based permit denials create unconstitutional classifications that treat Americans differently based solely on where they live. And third, the court invoked the anti-commandeering doctrine, which prevents states from using local regulations to effectively nullify federal constitutional rights. Each of these tests individually is extremely difficult for gun control laws to survive. Combined into one unified framework, they create a legal gauntlet that is essentially impossible to pass. The equal protection angle is particularly brilliant and deserves special attention because of how it changes the strategic landscape. By ruling that residency requirements trigger strict scrutiny, the court gave Second Amendment advocates a second powerful constitutional weapon. Even activist judges who personally despise gun rights find it nearly impossible to dismiss an equal protection claim. The principle is straightforward and deeply rooted in American law. If you provide a right or service to residents, you cannot deny it to law-abiding non-residents. Period. The judge identified what legal scholars are now calling constitutional dead zones, geographic areas where fundamental rights simply evaporate when you cross a state line. And she made a point that is devastatingly simple. You don't lose your First Amendment right to speak when you drive from New Jersey to New York. Your Fourth Amendment protection against unreasonable searches doesn't vanish because you're visiting from out of state. So why has the Second Amendment been treated as a lesser right for over a century? The court found that these residency-based systems violate the Privileges and Immunities Clause of Article 4, Section 2, a provision specifically designed by the founders to prevent states from creating second-class citizenship for out-of-state Americans. This is a constitutional provision that most people have never even heard of, but it was put there for precisely this situation. Let me tell you about the domino effect that's already underway, because the speed at which this ruling is rippling through the legal system is unprecedented. Within 72 hours of this decision being published, Second Amendment advocacy groups filed 17 new federal lawsuits across 6 different states, all citing this ruling as direct precedent. Attorneys in California, Hawaii, New Jersey, Maryland, Connecticut, and Massachusetts are incorporating Judge Fayle's arguments directly into their own filings. California alone is now facing 5 separate new challenges to its concealed carry permitting system, including one that specifically targets the state's good moral character requirement, which this court labeled an unconstitutionally vague standard that invites discrimination. Hawaii's entire May issue framework is under direct legal assault, with attorneys essentially copying the successful arguments wholesale, and state attorneys there are reportedly signaling they may not even mount a defense because this ruling makes their position legally untenable. The court established what legal experts call persuasive authority, meaning even courts in other circuits that aren't technically bound by this specific decision are likely to follow its reasoning because the historical analysis is so thorough and well documented that departing from it would practically guarantee reversal on appeal. Federal judges in other circuits are already citing this case in preliminary rulings, signaling that they find the constitutional analysis compelling. So what does all of this mean for you personally right now today? If you're one of the millions of Americans living in a restrictive state, this ruling hands you the legal framework to challenge virtually every aspect of your state's discriminatory carry laws. From permit requirements to sensitive place bans to ammunition regulations, the constitutional roadmap is now drawn. If you travel for work or family or vacation, this decision potentially opens up states that have been off limits for decades. For the first time in a generation, there's real legal recourse against the patchwork of confusing, contradictory laws that have turned law-abiding citizens into accidental criminals. And even if you live in a constitutional carry or shall-issue state, this ruling strengthens your position by creating constitutional guardrails that will be extraordinarily difficult for future legislators to overcome if political winds ever shift. The historical analysis in this decision essentially locks in protections that go beyond any single election cycle. There's also a psychological shift already happening on the ground. Law enforcement and prosecutors in restrictive states are beginning to realize that aggressive enforcement of carry restrictions is going to result in expensive federal civil rights lawsuits they're almost certain to lose. We're already seeing prosecutors in some jurisdictions quietly declining to pursue charges in cases that would have been automatic prosecutions just a year ago. The enforcement apparatus is starting to crack because the people running it can read the legal writing on the wall. What this court has done is validate what millions of gun owners have been saying for years, that most gun control laws are built on politics and fear rather than constitutional law, historical precedent, or genuine public safety evidence. The judges didn't just reject the government's arguments, they systematically dismantled them using the government's own historical sources and its own crime data, proving that these restrictions were never justified in the first place. The question is no longer whether the remaining restrictive states will fall, it's when. And based on the speed of the legal domino effect we're already witnessing, that timeline is much shorter than anyone anticipated. This ruling is the master key. It provides the constitutional framework, the historical evidence, and the legal strategy template for challenging carry restrictions from coast to coast. Whether you're in a free state or currently behind the lines in a restrictive one, the momentum is undeniably on our side. We are watching the demolition of a century's worth of unconstitutional overreach happen in real time, and it is accelerating. I want to hear from you down in the comments. Which state do you think falls next? Is it California, Hawaii, New Jersey? Drop your predictions below. And if you want to stay on top of every major Second Amendment development as it breaks, make sure you're subscribed with notifications turned on because the pace of these victories is only picking up. That's it for today, folks. See you in the next video.